Welcome to this module on the history of land ownership in America. My name is William Stephen. I truly believe that in order to be a proficient and professional title abstractor, you must have a good understanding of the history of this country and how we got to where we are today in the ownership of land. Enjoy the module. Let's get started. Let's now discuss the history of land ownership in America. To fully understand modern real estate title searching, it is necessary to understand the history of land ownership in the United States. Every deed, mortgage, easement, judgment, and title document examined by a title abstractor today is the result of centuries of evolving property laws, customs, and governmental policies. The American system of land ownership did not develop overnight. Instead, it emerged through a complex series of historical events involving Native American land use, European colonization, territorial expansion, wars, treaties, federal legislation, and the establishment of public recording systems. As title abstractors, we often focus on the current ownership of property and the chain of title extending backward several decades. However, every parcel of land in America has a much longer history. Understanding that history provides valuable insight into why land records exist, why recording systems vary among states, and why legal descriptions differ from one region of the country to another. This chapter traces the development of land ownership in America from pre-colonial times to the modern era. Long before Europeans arrived in North America, millions of Native Americans inhabited the continent. These indigenous peoples developed sophisticated social, political, and economic systems that governed the use and occupancy of land. Unlike European concepts of private ownership, many Native American tribes viewed land as a communal resource belonging collectively to the tribe or nation. Although practices varied widely among tribes, land was generally considered something to be used and protected rather than individually owned. Tribal members often possessed rights to hunt or fish, farm, gather resources, occupy certain territories. However, the underlying ownership frequently remained with the tribe as a whole. Numerous tribes established clearly defined territorial boundaries and defended those territories vigorously. Examples of major tribal nations included Cherokee, Creek, Seminole, Iroquois Confederacy, Sioux, Navajo, Apache, Choctaw, Chickasaw, and Shawnee. Many modern place names, county boundaries, and geographic features retain Native American origins. From a title perspective, Native American occupancy remains significant because tribal lands, reservations, treaty rights, and federal trust lands continue to exist throughout the United States today. European exploration dramatically altered land ownership patterns in North America. Beginning in the late 15th century, several European powers claimed vast portions of the continent. These claims were often based upon exploration, discovery, conquest, colonization, and treaties. The primary colonial powers included Spain. Spain established extensive settlements throughout Florida, Texas, California, New Mexico, Arizona, and the Southwest. Spanish land grants frequently created large ranches known as haciendas. Many southwestern states continue to recognize land rights originating from Spanish grants. France claimed enormous territories including the Mississippi River Valley, Louisiana Territory, Great Lakes region, portions of Canada. French civil law traditions continue to influence real estate law in Louisiana. England. English colonization had the greatest influence on American property law. English colonies were established along the Atlantic coast beginning in the early 17th century. Most modern American real property law derives from English common law. Concepts inherited from England include fee simple ownership, estates and land, deeds recording systems, mortgages, dower rights, easements. These concepts remain fundamental to title searching today. During the colonial period, land ownership was often established through royal grants. The English crown granted enormous tracts of land to individuals, companies, proprietors, colonial governments. Examples include Virginia Company, Massachusetts Bay Company, Lord Baltimore's Maryland Grant, William Penn's Pennsylvania Grant. Colonial governments subsequently conveyed smaller parcels to settlers. Early conveyances were often informal by modern standards, descriptions frequently referenced trees, streams, rivers, rocks, neighboring property owners. As a result, some of the earliest deeds remain difficult to interpret today. Title abstractors working in eastern states occasionally encounter legal descriptions derived from colonial-era conveyances. English common law forms the foundation of American property law. Common law developed gradually through judicial decisions rather than statutes alone. When English settlers arrived in America, they brought these legal principles with them. Several concepts remain critically important to title abstractors. Fee simple ownership. Fee simple ownership represents the highest form of private ownership recognized by law. A fee simple owner possesses exclusive possession, use and enjoyment, right to sell, right to lease, right to devise by will, right to transfer by gift. Most residential property in the United States is owned in fee simple. Estates and land common law created various ownership interests known as estates. Examples include fee simple absolute and life estate, leasehold estate, tenancy in common, joint tenancy. These interests frequently appear during title examinations. Dower and courtesy. Historically, surviving spouses possessed legal rights in the property of deceased spouses. These rights continue to affect title examinations in some jurisdictions. The American Revolution and public lands. Following the American Revolution, the newly independent United States acquired vast Western territories. The federal government faced the enormous challenge of surveying, managing, and selling these lands. Without an organized system, land disputes were common. The need for a uniform land system led to one of the most important pieces of legislation in American history. The Land Ordinance of 1785. The Land Ordinance of 1785 established the Public Land Survey System, PLSS. This law created a standardized method for surveying and describing federal lands. The PLSS divided land into townships, ranges, and sections. Townships measured 6 miles square. Each township contained 36 sections. Each section contained approximately 640 acres. This system brought order to Western expansion and remains in use throughout much of the United States today. For title abstractors, understanding the public land survey system is essential when searching title in Western and Midwestern states. The Northwest Ordinance of 1787. The Northwest Ordinance established procedures for governing new territories and admitting new states to the Union. The ordinance created territorial governments, established methods for statehood, prohibited slavery in certain territories, encouraged public education. The ordinance significantly influenced the expansion of the United States. Westward expansion. Throughout the 19th century, the United States expanded dramatically. Major acquisitions included Louisiana Purchase, 1803. Purchased from France, this transaction doubled the size of the United States. Florida Acquisition, 1819. Acquired from Spain through the Adams-Onis Treaty, Texas Annexation, 1845. Texas entered the Union as an independent republic. Oregon Territory, 1846. Acquired through agreement with Great Britain, Mexican Cession, 1848. Following the Mexican-American War, the United States acquired vast southwestern territories. Each acquisition brought different land systems and legal traditions. Consequently, title practices often vary regionally. The Homestead Act of 1862. The Homestead Act encouraged settlement of Western lands. Qualified individuals could obtain ownership of federal land by 1. Filing an application. 2. Occupying the land. 3. Improving the property. 4. Residing on the property for a specified period. Millions of acres passed into private ownership under this legislation. Many chains of title in Western states trace ownership back to federal patents issued under the Homestead Act. Let's discuss federal land patents. A land patent represents the first conveyance of land from the federal government to private ownership. Land patents occupy a unique place in title examinations because they establish the beginning of private ownership. Many title searches in Western states ultimately trace ownership back to a federal patent. Patents are still available for research through the federal government's online land records databases. Development of recording systems. As populations increased, it became necessary to establish formal recording systems. Public recording systems were designed to establish ownership, protect purchasers, provide public notice, prevent fraud, resolve disputes. County recording offices gradually emerged throughout the country. Today, these offices may be known as Recorder of Deeds, Register of Deeds, County Recorder, and the Clerk of Superior Court. The documents maintained by these offices form the basis of modern title searching. Industrialization and urban growth. During the late 19th and early 20th centuries, rapid urbanization transformed land ownership. New forms of ownership developed, including condominiums, planned communities, cooperatives, commercial developments, subdivisions became increasingly common. Recorded plats emerged as a standardized method for describing lots within subdivisions. Modern land ownership. Today, land ownership in the United States remains highly regulated. Ownership rights are affected by zoning ordinances, environmental regulations, homeowners associations, easements, government restrictions, taxation, federal laws, state statutes. Modern title abstractors must understand both historical and contemporary influences on property ownership. Why history matters to title abstractors. Many title problems originate from historical events. Examples include old railroad rights-of-way, unreleased mineral reservations, colonial land grants, boundary disputes, heirship issues, ancient easements, as well as federal patents. Understanding the historical development of land ownership allows title professionals to recognize and resolve potential title defects more effectively. Professional tip. When examining older deeds, remember that legal terminology, ownership customs, and recording practices may have differed significantly from modern standards. Always interpret historical documents within the context of the period in which they were created. Key takeaways. American property law evolved over several centuries. Native American land systems predated European settlement. English common law heavily influenced modern property law. The Public Land Survey System standardized Western land descriptions. Federal land patents established private ownership of public lands. Recording systems developed to protect ownership rights and provide public notice. Historical events continue to influence modern title examinations. Chapter summary. The history of land ownership in America provides the foundation upon which modern title searching is built. From Native American land use to federal land patents and modern recording systems, each stage in the nation's development has shaped the real estate industry. A professional title abstractor who understands this history is better prepared to identify title issues, interpret historical records, and appreciate the evolution of property rights in the United States. Now that you have a little more understanding of the history of land ownership in the United States, let's move on to some more topics in the real estate title abstracting procedures.